Welcome to this MBL webinar, The Law of Nuisance in Scotland, a Bite-Sized Guide. My name is Neil Morrison. I'm an advocate with Arnott Manderson Advocates in Edinburgh. So today we are going to look at what is nuisance. We'll look both at the private and public nature of nuisance. We'll consider the legal tests that have to be satisfied. Then move on to considering the leading Scottish authorities on nuisance. And we'll then look at the civil remedies that are available when an action of nuisance is raised. So let's now turn our attention to what is a nuisance. So nuisance concerns unlawful interference with, well, it could be the use or enjoyment of land, property, the comfort, health, or convenience that land gives a person. And there may also be public rights, which we will come on to discuss later in the webinar. But the key thing with nuisance is balancing neighbouring interests and ensuring that that both property owners, neighbours, can use their properties in an ordinary and familiar way, but there is a qualifier to that, which is that they must do so in a reasonable way that will not affect the other property owner and make their enjoyment of their property impact their enjoyment of the property, and also it will not make their lives intolerable. Now, there is some overlap between the common law and environmental regulation, which we'll come on to discuss. However, the law of nuisance has mainly been developed by the common law through cases. Now, the origins of nuisance, there's very much a Roman law influence and a Latin maxim which is really relevant and appropriate for nuisance is sic utere tuo ut alienum non ledas, which is use your property so as not to injure another. And of course, nuisance has been considered by the institutional writers in Scotland, Stair, Erskine, Bell, and indeed many others.